I am thrilled to be here. This is an interesting sort of homecoming in many ways. But before we get into Bridgeford and get into some really great conversation that I want to have with everybody in the room, I want to congratulate Scott and the FPA. You know, I've been in central Pennsylvania for a long time. I started out as a young lawyer in Lancaster, Barley Snyder for a long time, transitioned into the wealth planning space, and always was aware of the FPA. I was lucky enough in the early days of Bridgeford, I think, to present a few times. And what Scott and the current leadership have done with the FPA is pretty amazing. The list of attendees is extremely impressive from all over Pennsylvania. And what they're doing and the story they're telling is phenomenal. And that's something that Scott taught me, is the value of storytelling. And the story you're telling is useful to the community, useful to the planning community, and I think is amazing. So why don't we give you guys and the community a great round of applause. Because it takes a lot of work to put something like this together. I don't know if Scott's in the room, but Scott, thank you for all the support and everything you've done for Bridgeford over the years. I started to say this is a little bit of a homecoming because, you know, we had a big idea so many years ago, 2010, 2011. And when I say we, Terry Harris is in the audience. He's my co-founder of Bridgeford Trust Company. He, at the time, was managing partner of McConnelly and Asbury, who's also a partner of Bridgeford Trust Company. We have some McConnelly and Asbury people here, I think. Jeremy Peachy, partner, there he is up there. Well, you're way in the back. I can barely see you. We have Dan Sturm, I believe, here, who is not in the room yet. There he is. He's right next to Terry Harris. He's also a partner at McConnelly and Asbury. And McConnelly and Asbury, if you don't know, is a leading firm here in central Pennsylvania, doing tremendous work for large families all over central Pennsylvania and really all over the East Coast and up and down the East Coast and Mid-Atlantic. Melissa Roberson is our marketing director. I've been recently referring to her as our secret weapon because she's been with Bridgeford since before Bridgeford had a name, and everything that you see on our websites, everything you see in our digital media, which is not just sales, it's all about education. The look of it, the feel of it, the tone of it is Melissa, and so we can't thank her enough at Bridgeford. So again, why this is a homecoming? Because we conjured up this idea in central Pennsylvania of a new paradigm, a different way of looking at trust planning, a different way of thinking about how to go to market and bring what is the best of modern trust law to your clients. Because most, or if not everybody in this room, and by show of hands, you're a financial planner. You may call yourself something different in practice, but ultimately we're all doing planning for our clients, right? So we're all looking for the next big idea. We're all focused on doing what is best for the client. So the idea of Bridgeford and the idea of an independent trust company became paramount in what I think has become an industry wrought with conflict of interest. And when you look at sort of the big traditional bank trustee model at a bank in Newark Mellon, which is phenomenal, where I came from, or Wells Fargo, or you name it, the big box bank that has a trust company usually was just focused on managing money, and that's why they had the trust company, which is why the proliferation of an independent trust company became so important. We don't manage money. Companies like ours do not manage money on purpose. We're going to talk about mechanisms that have removed conflict of interest. I looked at the list, I recognized a lot of the names, it's great to see you all, and I know all of you also have become independent, a lot of you, to avoid what is conflict of interest. Right? Why you opened up your RIA, why you moved from maybe the brokerage model, whatever the reason, that's the story. Is going back to how Scott talks about, and I love the way he talks about it, the story of our industry has evolved in a way to avoid conflicts of interest. Why? Because the wealthiest families on the planet can see us coming. They see the conflicts of interest. The wealthiest families in the country, when they leave Bank of Newark Mellon, they're not going to Wells Fargo. They're going to you to do planning and managing money, and they're coming to trust companies like Bridgeford to give them sophisticated trust solutions. This large conglomerate approach, full of conflicts of interest, is starting to finally fail. Unfortunately, there's still some consolidation in the trust industry. Trust companies like ours are being gobbled up by large international conglomerates, so suddenly this conflict of interest problem that we created ourselves to fix is now becoming a bit of a problem again. That's why Bridgeford is determined to stay independent. We're privately held. We're the largest and oldest South Dakota-based trust company in South Dakota, which is something we're proud of, and we're not for sale. So the point is, this is a model, this is a new paradigm, which we're going to get to. But before we get into some of this, a couple requests of you. Please be interactive. If you hear something you want to comment on, jump in. If you disagree with me, wait till I leave and tell Melissa after. Fair enough? all joking aside, we love to engage with content. We love to engage with big ideas. I say big ideas a lot because this is what it's all about. And we're going to quickly run through what I think are some of the biggest ideas in industry. But we're on the threshold of a whole different geopolitical and national politically, of course, dynamic. We can't ignore, and this is a bit of a joke, sort of the elephant in the room or the elephant in the White House. I only say that because he's Republican. It doesn't matter whether you like Trump or not. I'm not here to take a political position. What I'm here to say is that we have to acknowledge the chaos that is coming out of Washington, D.C. Again, whether you love them or not, it's not the point. Are we going to have tariffs or are we not going to have tariffs? Is the IRS going to go away? Or are we not going to have an income tax? The Supreme Court, the Constitution, is that just now a punchline? And as a lawyer, I take that very, very seriously. So, not a political statement, but something I think we need to embrace. We are in a time, perhaps, of unprecedented uncertainty. We're all trying to tell our clients the right thing to do. Stock market's going up and down every time Trump opens his mouth, right? It's any president. And again, I'll be clear, whether you love him or hate him, there's been a degree of chaos that we have to figure out how to manage and harness. Because I've said for many years, and I believe it with my whole heart, which is why we started Bridgeford in the first place, is uncertainty can be a guiding light. You know, I'm a big fan of Bono, and he says, you know, hang in there, uncertainty can be a guiding light. So I think we need to take this uncertainty, take the tools that are available, and start planning. We don't know what tomorrow's going to look like more than ever. I mean, even on a national stage. I mean, some believe we could end up in a World War III. I'm not being dramatic. I mean, we're all seeing the news, right? And I'm going to say this, and I'll stand firm on it. I'm 52 years old, practiced law for a long time. I never would have thought that I would have to explain what's going on around us to my daughter in law school, who's confused by all of this. So I mention all this to get into, as a launching pad, to get into our story as to why modern trust law matters and why we want to talk about it, and why maybe sometimes Pennsylvania isn't going to be sort of the best jurisdiction. So at Bridgeford, we embraced a new paradigm. And here is where we want to begin. There have been more changes in our industry, the trust industry, but also our collective industry, the last 20 or 30 years, and has been ever probably in the history of our, I mean, think about your industry in particular. You went from being brokers to independent RIAs to being a family office to being wealth managers. I mean, even the way you talk about your own industry has changed, right? Not let alone all the changes in the trust industry. So I've said it a few times. Bridgeford was born to embrace a new paradigm. Here's what I'm talking about. Very quickly. You know, we have trusts now that can live forever in perpetuity. We're going to talk about that. Important tax play. We've unbundled aspects of trust administration and asset management that has what? Avoided, and I argue has removed the conflict of interest, which is so awful that you see in the big bank model. Conflicts of interest I've already mentioned. I've kind of already outlined why asset management is different. Non-traditional assets now are actually embraced in trusts. I mean, how many times have you had clients that went to, well, we'll call it Fulton or Bank of New York Mellon, and said, hey, I have a big piece of property that I'd like you to hold in trust. And then guess what they say? No. Why do they say no? Because they want to manage money. Well, the new paradigm allows trust companies like us to say yes. We'll hold closely held stock, we'll hold real estate, we'll hold crypto, we'll hold artwork, we'll hold planes. Where all the traditional trust companies, I assure you now, most of them will say absolutely not. That's a good development for our clients, right? Because trusts just weren't created so you can manage money. They were created to pass assets across generations, created for asset protection purposes, privacy purposes, which we're going to get to. And I've already mentioned there's this interplay between what is institutional and what isn't institutional. We at Bridgeford are not institutional on purpose. We will never be. The institutional model, big bank conglomerate, just doesn't work. You know that because you're not in that model. You've created your own boutique style. This is why the alignment of an independent trust company, whether it's Bridgeford or whomever else, is essential, I think, for the proliferation of your own practices, also essential for the proliferation of our industry. And it all turns on a couple of different concepts. You know, I mentioned the Dynasty Trust. We're going to go through all these concepts somewhat quickly because I'm aware of the time. And I certainly am happy to talk afterwards. But these are the pillars, if you will, of modern trust law. And I always say I think the modern trust law world was born in 1983 with the creation of the Dynasty Trust. Dynasty Trust essentially is a trust that lives forever. Nothing particularly complicated or sexy about it, unless you're a family who never wants your assets to be taxed by the federal government, your estate. So you may know Pennsylvania also has abolished the rule against perpetuities. So this is a concept, though, that was led by South Dakota, allows these trusts to live forever, and is a tremendous tax play, which allows, again, these trusts to live forever. You ask probably, why am I starting with this? Well, because often the planning you're doing for clients starts with tax questions, tax concerns. The folks at McConnell and Asbury are experts at this. They ask the right questions. This is a big question. This is especially for a large family. We need to talk about that and talk about what taxes mean. Talk about what jurisdiction means. So I told you a moment ago that, well, Pennsylvania has a dynasty trust, meaning they've abolished the rule against perpetuities. What they still have, though, is a state income tax. So Delaware, South Dakota, Nevada, the top tier trust jurisdictions, which is how we're going to end, do not have a state income tax. So if I said by simply putting a trust in Delaware, South Dakota, Nevada that doesn't have a state income tax, you can avoid taxation on undistributed income. Pretty compelling, only 3%, I guess, still compelling, especially for a large family. All by selecting the proper trust jurisdiction. What if I told you that if a business was sold inside of a trust sitting in South Dakota, Nevada, or Delaware, that you avoid state capital gains, Pennsylvania, or New Jersey? I know we have some folks maybe that cater to New Jersey as well. Would you think your client would think you're a rock star if you saved them $1 million in taxes just because you said, hey, we should think about another jurisdiction? I mean, I think we all can agree we're trying to bring value. Well, that sure is valuable, in my opinion, and I'm sure you all agree with me. So this tax question really drives a lot of the conversation, but that's just not it. There's also asset protection. And asset protection right now is so red hot and goes right to the chaos that we're seeing all around us. We don't know what this is going to look like. As I said, is there not going to be a tax? Are tariffs going to ruin small businesses? Who knows? I regret the chaos, but we still have to embrace it. So asset protection in its purest form is a way to give families some solace and allow them to sleep at night. Pennsylvania does not have a domestic asset protection statute. This is why jurisdiction matters so much. South Dakota, Nevada, Delaware, Alaska, top jurisdictions in the country for asset protection. You might be saying, David, what are you talking about by asset protection? I'm talking about creating a trust that's self-settled by your client that has the attributes of asset protection after 2 years, something called fraudulent conveyance, which means now more than ever, we have case law that supports it. Those assets are almost impossible to get at by a creditor, as long as there's no fraudulent conveyance. There's a case in California, or out of South Dakota, called Cleopatra. It's really the name of the case, I didn't make it up. That stands for the proposition that a South Dakota court is not going to allow a creditor to pierce that trust as long as it was set up correctly without a fraud intent. A case just came out of Delaware last week, I believe, that also stood for the same proposition. So remember the movie The Firm and this idea of, well, the only way you're going to get true asset protection is to go to Bahamas, Cook's Island, and maybe there's some truth to that still. But I've been arguing this point for years, at different heckling and different conversations we've had, and there are some attorneys who say, well, you can't get asset protection in the United States. I don't believe that. I think that's incorrect. I think we have case law that proves that now, and I'm excited about it. And I know your clients are concerned about it. And I think if you raise the question, they're going to love you for it, because we all want asset protection. And by the way, this isn't dirty two words. They're not dirty two words right here. The next thing we're going to talk about is privacy. Not a bad word too. These are the things that families want. These are the things that they're looking to us to give to them. I can get into more details of how the domestic asset protection trust works. I've already mentioned the idea of case law that supports it. We see these used all the time instead of prenups or in lieu of prenups because they're that powerful and they work. And they don't exist. There's no statute on the books here in Pennsylvania, and you need to know that, because if your client's worried about it, I don't care what the Pennsylvania attorney is going to tell you, the answer is if there's no statute on point called the Domestic Asset Protection Statute, then your client is not going to be able to use the trust as a self-settled vehicle to protect herself or himself. And there's a way to get the best of both worlds. There is a codified rule that I'm not going to read you or go through, but if you have a client who's really, really concerned and says, look, Mr. Planner, Miss Planner, I need my assets offshore because I'm really, really concerned, I will tell you there's a way to actually have both, just by virtue of invoking an obscure law in South Dakota. And I'm happy to answer more questions about it. The issues in Switzerland taught us that there was a distinction, right, between secrecy and privacy. And this quote embodies it in my mind. I love this quote because it points out in particular detail, hey, we're not trying to hide information from the government. We're trying to hide information from the public, personal information of wealthy, any family. It doesn't have to be a wealthy family, any family. And so now we're talking about privacy. And privacy, just like asset protection, they're not bad words at all. And we're going to quickly define it, and then I want to talk about some issues that we're facing in our industry. But essentially what we're talking about is the ability to keep private information from being public. Say it again so I'm clear. Private information from being public. So again, you might be saying, David, why does that matter? Because I think we all have a right to privacy, don't we? Everybody in this room, all of our clients, we have a right to keep our information out of the public domain. You might be saying, yeah, no kidding, David. Well, the laws in most of the states in the United States don't stand for that proposition, even Delaware. So unequivocally, South Dakota has the most powerful privacy provisions. It's not my opinion or Terry Harris's opinion. This is the opinion of Trust in the States magazine, and practitioners, professors, people from all over the world have looked at South Dakota as having the best privacy provisions. And now, perhaps more than ever, I talked about the chaos and the craziness coming out of Washington. Maybe privacy is more important now than it's ever been. Think about it. And so the idea, and there's another aspect of privacy called a quiet trust, which is important. It's really the ability for your client to keep the information about the trust quiet. No forced rule, or no rule that forces them, I should say, to tell next generation or tell beneficiaries that the trust even exists. So these concepts have become so important, and I keep saying especially now. I mean, how many of you watch the burgeoning Corporate Transparency Act and were happy when it failed? So you can raise your hand. It's okay. I'm gonna report you all now to the government. Look, from the very beginning, I took a hard stance. It was a little controversial. I thought it was overreaching. I thought it was ridiculous. I thought it flew in the face of fundamental ideas of privacy. And I thought from the beginning that whole Corporate Transparency Act was never going to achieve the objectives. It was impossible for it to achieve the objective, which is to catch nefarious actors. Nefarious actors were just going to go somewhere else. So the rest of us, trying to do the right thing for our clients, walked into an administrative quagmire, which thankfully some adult in the room or some judges in the room realized it was a bunch of BS and it was unmanageable, and it went away. But I could tell you at Bridgeford, we were shocked at the amount of upset this created, because they thought, and it really was in many respects, too much of an encroachment on privacy, which is a fundamental right. It may not be a constitutional right, but in my mind, I think all of our families that we serve and all of us in this room have a right to privacy. And the way to, and you might be saying, and some people say, yeah, but what about the bad actors, and how do you root that out? Well, that's what KYC is for, and that's why we're careful about the way. None of us want to be on the front page of the New York Times or work with a drug cartel or be in bed with some, axe murderer somewhere in Pennsylvania. I don't know. It could be anywhere. It doesn't have to be in Pennsylvania. But here's the problem that we're now sort of looking into or bumping into. Publications like The Atlantic and other publications and commentators have said, hey, wait a minute, South Dakota and Delaware and you sophisticated planners, you're bad people because you're helping rich people avoid taxes. And you're a tax evader. And Bridgeford, why are you giving asset protection? That guy came to you because he's bad. That's why he wants asset protection, because he's a bad guy. And I reject that right out of hand. What we're doing absolutely in this industry is virtuous. And we're not selling secrecy, we're not selling tax evasion, we're not giving asset protection to families who don't deserve it. We are doing the best we can, and I encourage you to embrace the modern trust law new paradigm, because that's where your clients are going to get it. And by and large, you're not going to get it out of the trust laws of Pennsylvania. That's for certain. So the foundational, so we talk about these various benefits: taxation, asset protection, privacy. All in the context of, great, David, but my clients are afraid of irrevocable trust because, in the old days, in the old paradigm, they were unworkable, expensive, hard to deal with. You couldn't choose your own asset manager. High turnover at the big banks. All the reasons, right? All the reasons that actually force planners and attorneys in particular, and sometimes CPAs, to recommend Uncle Bob to be the trustee instead of Fulton or Bank of New York Mellon or PNC. And I'm not being ungracious to this. It's a model, it's a paradigm, and it worked for many years. It just has fallen apart. And it's been so bad that it actually has forced, as I said, people to put individual trustees in a position of power who don't know how to be a trustee. So can we all agree that, while the industry became so awful that we had no other choice but to evolve into putting an individual who doesn't know what they're doing into a trustee role? Yeah, I get that we needed a better solution. I'm here to tell you now this pendulum's swinging back. There is another solution. There's a better solution. It's called an independent trust company that relies heavily on the directed trust. How many people in the room have you worked with or know what a directed trust is generally? Excellent. So in my opinion, this is a revolutionary aspect of trust movement across the last 25 years. And everybody laughs at me when I say that because, when I was in law school, I always say I hated trust in estates because I thought it was boring. Now here I am working up a sweat telling you how much I love it, right? It's kind of a weird evolution in my personal life. But the point is, it's exciting to get and understand what a directed trust is because it essentially delivers power and control and direction back to your clients where it belongs. It delivers direction and control to you as their trusted advisor where it belongs. And it's not complicated, and the words are clear. And here's a schematic. The fancy way of describing it is that it bifurcates liability such that it allows Bridgeford Trust Company as an independent trustee to work with those of you in the room, God bless you, those of you in the room who are an asset manager and you retain your liability, we retain our liability. If you put everybody in Bitcoin, not our problem. If Terry Harris absconds with everybody's funds, not the asset manager's problem. Anecdotally funny, but the reality is that fiduciary liability was always the block. It was always why Bank of New York Mellon would say, no, Bank of New York Mellon needs to manage money because we have a fiduciary duty. So along comes this. No, you don't in a directed trust structure. So the end user client, guess what that means? They could pick whoever they want to manage the money. Not a bad solution, right? Because that's probably one of the biggest complaints I've heard. And when I was at Bank of New York Mellon, again, a great organization, I have great friends there, I have nothing negative to say except their paradigm is broken. It's not their fault. System's evolving, they're not. And the biggest families, when they get excited about the ability to make their own decision from a financial planning, asset management perspective, it's a game changer. It's a total game changer. I don't usually like that word, two words, but it is something that has changed our industry in such a compelling way. Pennsylvania has passed a version of a directed trust statute. So has California. And I would argue, and I don't say this just because I own a South Dakota trust company, but I would argue that statute is poorly written and doesn't define actors well enough. It doesn't pull apart the fiduciary duty well enough, and it doesn't create what is called an excluded fiduciary, which is a legal technical term and the heart of why the directed trust works and why you're protected and I'm protected and we're all protected from bad acts from one another. So I would encourage you, if a lawyer says to you, hey, Pennsylvania, you're good, you can leave it in Pennsylvania to have a directed trust statute, I would push back and say, well, tell me why that's better than South Dakota's or Nevada's or Delaware's, because the way I described it, the top tier trust jurisdictions have done it this way. It's because it's the right way. Pennsylvania didn't do it this way. Neither did California. And I don't know what all the other states are doing, but they're running around saying they now have modern trust law. Why don't they just copy what's already been built instead of trying to come up with something of their own? Because it's not as good. And I would argue, if it's not clear, then the liability is not bifurcated, and this whole thing collapses if there's a lawsuit and one of your, a crazy beneficiary comes after the both of us. So I would just be aware of that. Trust Protector is another aspect of what we do, which is really, really exciting, because it delivers more direction and control. You have a statute in Pennsylvania, but it doesn't define it very well. And I only chuckle because, I'm licensed in Pennsylvania to practice law. I love Pennsylvania. I don't have any particular axe to grind, except that I don't know why they're not looking around the world and just following suit with other. It's not rocket science. To write a statute that actually makes sense is not rocket science. So the statutes in South Dakota in particular enumerate 12, 13, 15 specific powers you can give to the trust protector. making them a super trustee, as we say. And you may again be saying, David, why do I care about that? Because your client wants somebody in a control position to be able to fire Bridgeford, to be able to change Citus, to be able to change the asset manager. And they can do so many, change beneficiary status in terms of how much they get or how much they don't get. Pretty powerful, we all would agree, right? Well, your clients want this. All part of the modern trust law new paradigm that we're facing. Your clients want to have this kind of flexibility and this kind of control. And the directed trust and the trust protector delivers that. And I'll say again, I would be very careful about a lawyer in Pennsylvania telling you, well, they can do this all in Pennsylvania. And I'm not, this is a little bit of editorializing, but it could stay in this room, right? Just us? Come on, you guys, you with me? Come on. Thanks. You know, having practiced law for years, you see where lawyers fall into the pattern of just doing what they've always done over the years because their senior lawyer gave them the, a template trust document or template will. I know you guys in McKay and Asbury see it all the time, right? Where the attorneys just kind of do the same old thing, and then somebody like David Warren comes in and says, hey, you can do asset protection out of South Dakota and Delaware, and look at all this stuff. They look at me like I'm crazy, or they think I'm selling them like a scheme that doesn't work. And I'm saying in Pennsylvania in particular, we have resistance because they just haven't seen it before. So if you haven't seen it before, well, it must not work, right? Well, I must have made it up or it must be nefarious. I forgot to mention, at the beginning, we have rep offices in Miami, a rep office in Southern California, and we have 2 offices that actually administer all the trust in South Dakota. We're coming up on 17, 18 billion. The reason why I mention that is because we're lucky to be national. We're lucky to be working with families all over the world, which is telling me that Pennsylvania needs to kind of catch up here in all of this. We're very excited about our Philadelphia launch. So we are in Philadelphia. We have an office in Philadelphia on Market Street, partnering with McKay and Asbury, and we like the multi-jurisdictional presence because it keeps us sharp. And when I'm sitting in a room with an attorney who pushes back on me, I say, well, in Philly they're doing this. We're talking about this at the FPA. If you don't know this, you got to know it. And we're going to get to my sort of argument at the end. And if they don't know it, could be malpractice. Nobody likes that word, right? When you're a lawyer or a CPA. But it's true, and I'm going to show you some case law and some statutory authority for you to say, if an attorney pushes back and says, no, they're fine in Pennsylvania, your answer is going to have to be, you got to get another attorney, and you might push back and say, well, you might be committing malpractice by saying that. I say the same thing in California, makes people uncomfortable, but sometimes we need to be uncomfortable, especially now more than ever, because I think there's a lot of reasons to be uncomfortable. So those are the 2, I think, aspects of direction and control. The trust protector is a fiduciary, and we all know what that is because we all like to say we are a fiduciary. Some people won't serve in that role if they're going to have to be a fiduciary because that carries a heavy burden, as we all know. So South Dakota figured that out, created a trust protector light, which has less responsibility and control, but also no fiduciary liability. And the reason why they did that is because of people like you, trusted advisors, often the first phone call that your clients make are saying, hey, I want you to be trust protector, and you're going to say, I don't think my compliance people are going to want me to do that. And they're going to say, yeah, but I love you. You're the reason why I'm here. I've been with you for 20 years, and they're going to want you to be, how many times have you been asked to be a trustee for your clients? Because they love you and they trust you and they don't want to go to a bank and they don't want anybody else in their business. So the solution is either for you to be a trust protector, and I understand a lot of compliance folks don't like that, but this is the next best thing. You being a family advisor exonerates you from the burdens of having a fiduciary duty, but still puts you in a control position that your clients want you to be in. Right? Our business is still relational. For you just say, oh, go to Bridgeford and you lose all control is not good for your business, but also not what your client wants. So this is, again, the continuing theme of the power of modern trust law. So here's a question. What if you have a client that has a trust that's been at Fulton for 30 years, not directed, no asset protection, none of the things I'm talking about, no bells and whistles that you can get. Is it easy to change? Yes, it is. It's called decanting. This is another aspect of control. and the ability to keep control over what the trust looks like. It's very much like a bottle of wine that you decant. It takes an old, tired trust with provisions that might not be working properly anymore and allows you to pour it into a trust with updated modern trust law provisions, move it to a jurisdiction that is more favorable, like South Dakota or Nevada in particular. And I would argue South Dakota and Nevada are far superior to Delaware, whatever anybody tells you out of Delaware. Yes, please.
Question, because where the rubber meets the road, people have to deal with an attorney.
Mm-hmm.
And I'm still seeing IRAs and trusts pay out at 25, 35, explosive language. I've had clients literally, they left money and it was paid out at 25 and their son was a drag addict.
Yeah.
Because they just dumped half the money.
Right.
And they would have done something else. I've had 2 families lose their shore homes because through divorce, and they had everything. How do you get attorneys to A, have the correct language? And the language is so important. I mean, most of our IRA trusts are explosive when you see the language that's out there. They're conduits and
right.
Put it all out, and they don't know how to deal with this stuff just to get it to you. Because they're junk. A lot of these trusts are simply junk, that way they're written. I
completely agree with you. And it's such a delicate dance, right? So I can sit here and talk like I'm a prophet and tell you all these great things, but if you're too aggressive in the boardroom of the attorney's office, they're going to get pissed off at you, and they're going to see you as a competitor because they want to be the smartest person, he or she, in the room. Often they're not, and I say that as a lawyer. So to your question, it's just a delicate dance. Sometimes people bring us in to argue with the lawyer. So you don't get into it with the lawyer. So you keep your relationship. Say, hey, why don't you talk to Dave Martin of Bridgeford? I don't care if the lawyer likes me or not. I'm happy to say to him, well, this is what they're doing in Miami, LA, New York City, London. I mean, these are worldwide concepts. So if the lawyer is comfortable letting a trust explode, like you talk about, again, malpractice. I've challenged lawyers directly, saying I think what you're doing could be malpractice. I think you could get sued if this blows up the way it looks like it's going to. So you could use us in that way, and so you avoid the confrontation. But it's a great question, and it's sad because we see it all the time, not only in that context, but so many times. If a doctor, I used to do a lot of part of my practice when I practiced law was representing doctors and hospitals, medical malpractice disputes. If they just had a domestic domestic asset protection trust existed back then out of Delaware. It would have saved them a lot of money. It would have really helped them out, right? If the lawyer in Pennsylvania, and I'm not going to mention the law firm, decided not to mention it because they just didn't believe in domestic asset protection, and this guy loses his shirt because of it, that's got to be malpractice. The biggest malpractice question to me is, I told you that just by putting a trust in Delaware, Nevada, South Dakota, any other jurisdiction that doesn't have a state income tax, that there are very real, measurable ways to save on taxes. So if you're at a cocktail party and your buddy's like, hey, I'm with Bridgeford, we saved $1 million when I sold my business, and this guy's like, well, shit, I just paid $1 million to the state of Pennsylvania. I mean, you can measure that damage, right? That's measurable. So what I'm saying is, to your point, I think you can take the moral high ground a little bit and say, look, are you worried about the best interest of the client or not? Or let me say it. I don't mind getting into the argument, as Terry will tell you. So that's decanting and when to use it. When am I forget when I'm done.
You got 45, 15 minutes.
Oh, I got 15 more minutes. I can get through. Okay. I thought I had all afternoon. All right. So decanting doesn't exist in all the states. Pennsylvania does not have a decanting statute. Unequivocally, South Dakota happens to be the best. It's been considered to be the best. And you may say, what makes it the best? It's the flexibility. It's the ability to move and change. In fact, South Dakota doesn't even have a requirement to notify beneficiaries. While prudent, not always necessary. So again, you might be saying, who cares? Well, when you're dealing with an old trust or you get a new client and you're looking at a trust and you say, look, I want to manage the money. They want me to manage the money, but right now Fulton or Bank of New York Mellon or PNC has to manage the money. Well, here's the way for you to manage the money. And I don't mean to be so Machiavellian about it, but your client wants you to manage the money. So let's get you there. Let's do it through a decant. And there's a little known law too, by the way, that I've used multiple times. And again, I'm not suggesting I'm the smartest guy in the room, and my business partners will tell you for sure that I'm not. But I had known right when we started Bridgeford, I did a lot of research because we didn't have any clients and nothing else to do. I found a law on the books that makes it very, very, very easy to change situs for a Pennsylvania trust. And there's case law on point in Pennsylvania that makes it very, very easy. So I've gone head to head with some of the biggest trust companies in Pennsylvania, and I've written a letter, and I'm like, you got to look at this law. This trust is going to leave. It's going to go to a different jurisdiction, period. And a lot of the lawyers don't know that. There was a great lawyer in Harrisburg, not going to mention his name. I have tremendous respect for him. We argued about it. I sent him I sent him some case law, and I sent him the statute. And this guy with the biggest ego on the planet Earth actually called to apologize to me. And I wanted to record it, but it's against the law in Pennsylvania, right? Wiretap issues? All right, anyway. So now we're going to get into, I guess, this idea of, do we have a duty to do this? So there's a case out of Massachusetts Supreme Court, and there's a couple of other cases that talk about this idea of a duty to decant. So now we know what a decant is, which is taking an old trust and making it new and modern and more tax efficient, asset protection, all the things we were talking about, privacy. But if a trustee knows that a trust, in this case is in Massachusetts, the assets could be in peril because it's not in a top-tier trust jurisdiction, the court raised the question, well, isn't there a duty then to decant it or move it to a jurisdiction that has better trust laws? Because what is the fiduciary duty of the trustee? To protect the trust assets. And if being in Massachusetts subjected trust assets to 3 times more taxation than if it were in South Dakota, or there's no asset protection provisions, or none of the modern trust laws I'm talking about, trust law tools I'm talking about, then why would a court not find that trustee is derelict in its duties? You look at New Jersey. I always use that as an example. High tax states. A lot of trust companies in New Jersey. Well, a trust company is not going to say to their client, hey, I think we should move your trust to South Dakota, because they don't have South Dakota trust powers. Oh, there's that conflict of interest again. Keeps coming up, right? Keeps coming up. Of course they're not going to tell the client to move to a different jurisdiction because they want to manage the money and they don't want to lose a client. So we have that's a conflict that we need to deal with, and I've been pretty outspoken about it because there is a lot of data and a lot of support in the seminal writings that I had to suffer through law school actually delineates a fiduciary duty, not only on the part of the trust company like a Bridgeford, but also you potentially, and also for sure lawyers and accountants, which is, and I'm not going to go through and read all this to you, but there's all these different writings on explaining how to be a trustee. And all of them have the same general language that says, well, you have a fiduciary duty to do this. If you're at Harrisburg Country Club, or you're over here at some country club around here, and you get into this conversation about, well, after hearing me talk, geez, you're talking to somebody at the bar, and they're like, oh yeah, my trust is in Pennsylvania, and I'm worried about asset protection and everything else. I mean, although they're not your client, you would say to them, well, where's your attorney? Where's your trust company? Where are the people? I mean, we're not making this up. These modern trust laws, I keep saying modern within the last 20 years. And these weren't on the books yesterday, right? And that's the other thing that I get kind of impassioned about. This isn't brand new stuff, and it's not even hard or complicated. It's out there, and when people don't talk about it, I am of the belief we're years away, if not sooner, of a case right on point that hits an attorney or perhaps a financial advisor who's a fiduciary now, or a trust company like Bridgeford on this very point. Because wealthy families have had it with the conflict of interest. I said that earlier. That's why they're leaving at Bank of New York Mellon, perhaps, and going to you and coming to us. They want it all bifurcated. They're tired of being cross-sold. They just want you to look out for them and focus on them. I'm not talking about it in the context of a punchline. That's our duty. That's why we're here, right? And so I think we can't take that lightly, and I guess I get pretty passionate about it, but it really is something that we can't forget about. So a good way to kind of wind down, and I'm happy to answer any questions, but this was a quote, was a really guiding light for us, because when we were conjuring up Bridgeford, we deliberately put ourselves in South Dakota for reasons that you can imagine. We'll see on the chart. Could have gone to Delaware. We had the money to do that. We had the money to go anywhere we wanted. We chose South Dakota. I always say, though, that, and this is a quote that is guiding, is where to put the trust today is as important as even a decision to create a trust in the first place. And that's a worldwide question. If you haven't noticed, the New York Times articles and all the things that are happening, the United States has become a tax haven, a privacy haven. So not only is jurisdiction important to which state, you have countries around the world are looking at, I mean, families from around the world are looking at jurisdiction and coming into South Dakota because jurisdiction matters because every state has different trust laws. And so I've already mentioned the top ones, you know, Delaware, because as one of my partners says, there's always an East Coast bias about Delaware, and they were certainly the leaders in many respects. And I'm not criticizing Delaware. I like Delaware. I just don't particularly like their trust laws anymore because they haven't kept pace with South Dakota and Nevada in particular. They have, the asset protection is clunky, meaning it takes longer for you to get the protection. Privacy provisions are weak compared to South Dakota's. So I'm not disparaging the state. I'm saying, well, you can have good, but why not have the best? And you know, the argument is, you know, we believe South Dakota is the best, and we have a chart that goes through that. And so I'll quickly kind of just point out some things, and it's in the materials. But you know, we at Bridgeford, we just didn't start a business. We launched a vision, and it was an idea that the trust industry needed to change. It was a new paradigm, like I said, and we hit a nerve, and we're humbled, and we can't even believe the position where Bridgeford is coming. I'm not saying that to brag about Bridgeford. I'm saying that we became true believers in what we were doing. Like I know most of you in this room are true believers in what you're doing for your clients. So it's easy for me to get excited about this. It's easy to be proud of our offices and our growth and how much we have under administration, as I mentioned. I mean, for a company launching out of central Pennsylvania to have almost $18 million of assets under administration is pretty amazing to me. It makes us a player worldwide. And again, that's not being braggadocious, it's fact. And you know, we always say we're going to remain independent. We're going to remain independent, and we are going to be boutique, and we're going to be always big enough to matter, but small enough to care. Yeah, I'm sorry.
Yeah, no, you're doing a great job, and this is fantastic. For all of these trust options, is there like a base minimum trust amount? Can I start with $1 million or $500,000? What's that number from the cost effective?
I love that question. So the question is fees. How are they feed? What's the sort of threshold? What size family? And so I'm going to answer it from Bridgeford's perspective because our competitors are a little different. And this is one of the things I love about what we're doing. The fees are not onerous. Flat fee approach at Bridgeford. It's really tied to scope of service more than anything else. And it has a tiered process. So I'll just give you an example. A directed trust that's under $20 million at Bridgeford, it's around $6,500 annually. When you add that to your fee as an asset manager or you know, in any capacity, it's going to be cheaper usually than any other trust solution in Pennsylvania for sure. And I love that because that's one of the problems that I couldn't get my mind around is why were these irrevocable trusts that have been at Bank of New York Mellon paying so much money, right? I mean, that doesn't make any sense to me. And Bridgeford's profitable. We're doing really well. I mean, I'm able to eat tonight, okay, and afford my Diet Pepsi. So we're not doing this as an act of charity. We're doing it as because we're a profitable company. But we can be profitable without screwing the client. Excuse the word, client. But no. And so the other question at Bridgeford, I don't believe in minimums. If somebody's worried about asset protection, if somebody's worried about tax planning, I don't care if they have $1 billion or $500,000. They're entitled to what we are bringing to the marketplace. I think it's arrogant to say, well, I mean, for us, asset managers is different because you have to scale up, and I'm not speaking to how you guys approach your fees. But how Bridgeford approaches our fees, in my opinion, if I'm going to believe in what we're talking about, it should be available to everybody. Because of the conversation, it's usually, you know, a couple hundred million. I don't know what our average account size is, Terry, but it's whatever, 20, 30 million. But we have account sizes that are 500,000. We just figure out a fee structure that works. And if they come to us and say, you know, we want asset protection, we're going to give them asset protection. And I think also, you all know this, you say no once to a client, and when they are $1 billion, they're never going to call you again, right? So that's just good business. And I'm just adamant about it. And I think it's an aspect of our industry that I'm going to stand firm on. Yeah.
Thought an hour ago you were going to talk about the prettiest ballerina is in South Dakota. It's like, okay, who cares? But we should. For these illiquid assets, because we're having that issue with shore homes.
Yeah.
In the $5 to $10 million
Absolutely.
arena is not unusual around here. Down in Jersey, that's where I'm from.
Yep.
Is there any issue? Do we have to pre-fund these trusts when they take over ownership? So there's to pay your fees, or is there no issue? Some guy throws it in and his family throws it in and they just start paying $6,500. It doesn't look like ownership. It's just like, hey, we're paying for service.
Correct.
Okay.
The way you said it's perfect. So the question is, do we have to pre-fund with dollars to cover our fees? No, we can invoice the fees separately, which is not a problem. We typically suggest shore homes or any homes go in sort of an LLC. It can be a Jersey LLC, it's fine, just because it keeps control with the family. They take care of the house. They don't have to worry about dealing with their trustee. And it's also a cheaper model, but we'll also do it the other way as well. I'm a Jersey boy too. I grew up in Vineland, and Avalon was my stomping grounds for a long time until they told me to leave. Yeah.
A lot of my clients' assets are within retirement accounts, IRAs, 401ks.
Mm-hmm.
Supposedly protected against creditors.
Great question. So the question is, the gentleman's clients are in 401ks, a lot of IRAs, not RIAs, IRAs. And are they protected? And the answer is yes. And that's why we typically say don't put IRAs or 401ks in trust, because they have asset protection. They have a lot of the ability to they have obviously tax savings. I mean, so those are vehicles that are still tried and true. We're talking about funds, assets that are outside of that. That's a great question. Yes, sir.
The community property trust
Mm-hmm.
that's there for South Dakota, is that like the Florida redevelopments versus stepped up basis for like a couple?
Exactly right. I'm glad. That was another tax. Thank you. And that's a great way to come to the end. It's another tax play. Community property trusts, as you know, when they're first to die, well, you may not know because they're relatively new. There's only 2 or 3 states in the country that have codified it, and now I know Florida's jumped into it. First to die, 100% step up in basis. Community property. Pretty compelling, right? And so what South Dakota has done is created a statute that says any property that's jointly held in marriage, through marriage, is considered community property, whether or not the person actually lives in a community property state or not. That's the magic of it. And the IRS has looked at this. It's been part of PLRs and has not been shot down. So the example of a client that's not in a community property state, married couple, sets up a South Dakota trust that has community property attributes, provisions in it, they will get the 100% step up in basis at the first to die. And it's huge. And you combine that with the other tax savings we've talked about, a Dynasty trust. I mean, we're talking about potentially tens of millions of dollars or savings over 100 years or 200 years. Thank you for that question. I wasn't going to get into it, but it's perfect. So I'm going to end here, my last minute or so. I'm a big fan of Bono, and you might not like him or not, but one of the things that I personally, I'm not necessarily speaking for Bridgeford, but I personally have become so passionate about, and part of my story, is I believe what we're doing at Bridgeford is a justice issue. I believe that everybody's entitled to asset protection, privacy, and I believe what we're seeing coming out of Washington is pure chaos. Again, not a political statement, it's just fact. And I think that this quote by Bono resonates for a lot of different reasons, but I think this idea of bending towards justice applies across the board, because it just doesn't happen naturally in our industry, politically, perhaps we're seeing. And so I want to end on this point, maybe somewhat controversial, and I apologize for that, but this is what drives the passion at Bridgeford. We believe we're doing the right thing. We believe this is sort of a form of justice that's being delivered, that modern trust law is bending our industry to provide. And I think it's something we should consider and always keep in mind that maybe things don't naturally occur. What naturally occurs are big bank trust companies who want to manage money that are full of conflict of interest. But when modern trust law bend the traditional paradigm and create a situation where you can deliver all kinds of control, asset protection, privacy, tax planning, all the things we talked about, that's the magic. And that's what I want to leave you with. So any questions? Great. Again, I don't know if you're in the room, I congratulated you on the growth and everything you're doing here. You should be really proud of what you're doing. We're proud to partner with this organization, and we're proud to be of use. So whatever we can do to help, support, answer any questions, we're here, and please reach out directly, and I'll be around today. So thanks for the questions. I really appreciate it, and thanks for the opportunity.